Okay, it is 8:30 p.m. Friday, May 3rd, 2019, and I am going to get started with the lecture. I've been kind of celebratory today being my 69th birthday. Some people says, you're working on your 69th birthday? Yes, because I wanted to make sure that my students had the information that's necessary to complete this course in an appropriate fashion. So I'm making that commitment. I made that announcement to you. So I'm going to go ahead and get started, and I'm going to share my screen with you. All right, and the information here, you're familiar with that. So I'm going to just scroll all the way down to your written assignment for the week, for week 6. The death penalty. The death penalty. Describe if the death penalty fits into the Constitution and if it is fair under the law. Describe the current state of death penalty in your state. In your state. Make sure you say your state, because some states have done away with the death penalty, and some states don't have it at all and haven't had it for years. I'm not going to say which states do. I know several of them, but I'm going to be reading your papers. Make sure that you have your citations and references. You're going to really have to conduct some research for this, okay? And then that's due. You'll see when that's due. And then your final project. Now, will you focus on the selected aspect that you started in week 2 and offer your opinion and its current state and what changes you would make and why? Make sure you include relevant case law and secondary sources. Remember, weeks before that, you needed to have that. You need to have those cases briefed so you can have the information there. Include a recent related case as well. Include an interview with a law enforcement professional. Now, when you did your interview on your last assignment last week, I did not require that you do the resume. Some of you did, some of you didn't, and so the assignments, those assignments aren't due until Sunday. So you don't really have to worry about that, but do make sure you have your citations in the body and references at the end. And then this is our final lecture. Today, May 3rd, 8:30 to 9:30, and I will give a keyword at the end. This is it. There are no more lectures, all right, because the course actually ends. You're going to see in a minute as we go over the schedule. So your week 5 announcement, we're not going to talk about that anymore because we talked about that. Crime and punishment. And you had chapters 12 and 13 of constitutional law that I sent you, and the activity, cruel and unusual punishment, which we're going to talk about tonight. Be sure to participate in a discussion assignment relating to DNA evidence. And then, finally, the written assignment, the death penalty, the 4th Amendment final project, and the final exam, which is timed. The final exam covers, it's comprehensive from the beginning to now. Though this stuff all pretty overlaps, and you should have the information based on the lectures that I covered, and if you paid attention to the materials that I sent you, the outline of the textbook, and those things, you should be pretty prepared for the test. Reminder that the quarter officially ends Tuesday, the 7th. So we got 4 more days left. Take time to complete the end of quarter student evaluations that you received in your email. You can do that at the end there after you finish everything. And then let's finish strong. Let's finish strong, okay? So that we're going to elaborate more on that in just a minute. But now I want to take you and remind you, look at the course calendar. And the course calendar will be up in a second. There it goes. And it tells you, this is where we are here for the live lecture. Your reply posts are due, well, you know already, that was for week 5. But I want to talk about week 6, your reading assignment, which you already know. We just got through talking about that. And then your initial posts and reply posts are both due on the same day relating to DNA, the 7th, Tuesday, by 11:59 p.m. Central Standard. I will not grade anything that the clock hits 12 on. It's got to be done before that. All right, and then your written assignment the same way. Also your final exam. And a reminder again, the quarter ends at 11:59 p.m. Central Standard Time, which means anything submitted after that will not be graded. Will not be graded. I'm telling you now. All right? So it's very, 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 very important that you understand that. All right? So that's the course schedule. So anybody who comes back later and says, I didn't know that the course ends on Tuesday, shame on you, because I've said it several times, and it is in the announcements. It's in your course calendar as well. All right? So now let's go to Module 6, which is our final module. And let's go over the assignments one last time. So your Fourth Amendment final project is due. And then I already gave you feedback on your previous assignments. I haven't done week 5 yet, but I will be doing week 5 project right away because they're due Sunday. But you want to make sure that when you get to this one that's due Tuesday, that you're going to focus on, you're going to provide each of these bullet points. Remember, your paper needs to be 6 to 8 pages, and use APA guidelines for citations and references. That's what it needs to be. Very, 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 very important. And then you want to make sure you cover all of these requirements. And notice that they relate to your assignments starting with week 2, picking the topic, week 3, week 4, and then finally week 5, the interview, okay? And then you're going to have citations and references. 6 to 8 pages does not mean 6 to 8 pages to the cover page, and the page for references is not counted. If you count those, then we're talking about 8 to 10. But 6 pages at a minimum of content material covering each of these issues. Very, very, very important. Very important. And then your death penalty is only a 1 to 2 page. Make sure you run your papers through Grammarly as well. By this point, your bachelor completers, you should know about critical thinking. You should run your papers through Grammarly. You should not have a high percentage. Your percentage should not be above 25, but an average is 10 to 15%, as I've been saying through the whole course. And any of you who had me in other courses know what I'm talking about. So you're going to write your written assignment on the death penalty, and you're going to cover each of these questions. All right? 1 to 2 pages. If you write more, that's fine. And then, of course, your DNA evidence issues, you're going to deal with Juan Rivera and Jerry Hobbs are just 2 of the cases where the suspects were exonerated due to DNA. Review the cases for this discussion. And then after you learn about these, then you're going to answer these questions in your discussion post. Then your final exam consists of 19 multiple choice questions and 6 short answer questions for a total of 25. It is time for 1 hour. So you'll have an hour to deal with 19 multiple choice and true-false questions combined. I can't tell you how many are going to be true-false or how many are going to be multiple choice. I can't answer that for you. I will not do that. And then you need to be prepared to answer the short answer questions with enough information that lets me know that you know the details. You cannot have your books, your notes, or any of those things. You have only one opportunity to complete this exam. And then I already told you when these assignments are due, as well as the key phrase that I'm going to give at the end of this session. That's due to get your final 10 points. Okay, so those are the assignments. Any questions? Reach out to me. Do not try to reach out to me and say to me, look, I had a work schedule, I couldn't get it done. I can't help you at this juncture. We have got to, this is only 5.5 weeks. I've been talking about it since day 1 and week 1, okay? So now let's go to the content material. Okay, we're going to deal with the 8th Amendment issue. So we're going to talk about cruel and unusual punishment. We've already talked about the final project, the written assignment, and the discussion, and the final exam. We've already done that. Okay, so let's talk about the 8th Amendment. So the 8th Amendment deals with a number of issues, but the death penalty is one issue, cruel and unusual punishment. And so this case, Miller versus Alabama, which was argued in 2012, is one of the most recent cases pertaining to the 8th Amendment. And the question was, can a person under 18 years of age be sentenced to life without parole for the offense of murder? So the issue is, does this violate cruel and unusual punishment or the 8th Amendment clause to the Constitution? And there are 2 cases that are appropriate that you should be aware of. First one is one that many of you should know from taking my criminal law class, and that is the issue of sentencing adults and in sentencing minors. Okay, so the Supreme Court said that minors shouldn't be treated like adults in sentencing because, remember, we've already talked about this in other classes. It's different sentences. We talked about different processes, different goals, and so forth. And so Roper versus Simmons, and you see the appropriate Supreme Court site, says that if a minor is charged and found guilty, they cannot be sentenced to the death penalty. That is a flat-out rule. And all 50 states have to follow that because the United States Supreme Court finally spoke on it to bring it under one rule. The Supreme Court rule is supreme. And then in 2010, in Graham versus Florida, the Supreme Court ruled that it's unconstitutional and a violation of the 8th to sentence a minor to life without parole for crimes other than murder. Other than murder. Murder is exempted. And it talks here that the reason for the ruling is the age and diminished capacity of a younger person prevent them from having as much moral culpability as adults have. So the point of the matter is that they cannot be sentenced to a life sentence without a possibility of parole unless it's murder. Unless it's murder. Okay? And the court takes a position that a young person can be rehabilitated if given the chance. But remember, adults can. All right? So the Eighth Amendment is, in this Miller case, involving a person under 14 years of age where they can be sentenced without parole for the offense of murder. Or does it violate the Eighth Amendment to the Constitution? So that case pretty much has laid it out that it can in cases where murder is involved, all right? So you want to take a look at that case as well so you can determine that as well. If you clicked on this, it will take you to the transcripts themselves, okay? And it will let you know, these are the oral arguments for various cases, but that's where you can actually find the transcripts themselves. So that's why I showed you that, all right? But anyway, it's an issue that's still not resolved yet, all right? So if you go and you do some research and you go and you look under Miller versus Arizona versus Alabama, not Arizona, you'll find the decision now, 567 U.S. 460, which is the citation of the actual case, decided in 2012, where the United States Supreme Court held that the mandatory sentence without the possibility of parole are unconstitutional for juvenile offenders. Okay? All right? And so the point of the matter is that at this particular point, it's pretty clear that in most cases, juveniles cannot be sentenced without a possibility of parole. All right? So you have that, and it's very, very clear. Now, it says here that the United States Supreme Court, in holding the mandatory sentence of life without the possibility of parole unconstitutional for juvenile offenders, the ruling applied even to those persons who had committed murder as juvenile, extending beyond the Graham versus Florida case, which it ruled life without parole sentences unconstitutional for crimes excluding murder. So what does that mean? That means just what I tried to say to you earlier, that if you research it, you'll discover that it is period clear that the Miller case is a ruling that does away with the decision of Florida v. Graham in terms of a 2010 case, which ruled that it is unconstitutional in violation of 8th sentence a minor to life without parole for crimes other than murder. Well, the Miller case came back and said, well, we don't like that because we want to be able to salvage individuals. And so the Miller case fixed it. So it prohibits a sentence that requires life in prison without the possibility of parole for juvenile homicide offenders, which involves murder. So now you got it. Now you have it, okay? So all in all, that simply means that it is a violation of the 8th Amendment, and in these cases interpreted that an individual who is a juvenile cannot, of course, be sentenced to death under Roper versus Simmons, but under Miller versus Alabama to a life sentence without a possibility of parole. Can't exist anymore. All right? That's a minor only. Now, we're not talking about adults. So now let's talk about DNA evidence and exonerations. One of the most revolutionary changes that has taken place in the criminal justice system, in my opinion, involves the DNA evidence. Many individuals have been placed on death row or received life sentences, and subsequent to that, when DNA evidence came about, it made it possible to determine that the individuals could not have committed those offenses. It revolutionized and created a lot of reversals for wrongful conviction. And two of the cases here that you take a look at are Juan Rivera, where the prosecutors would not dismiss the charges against Juan Rivera, and he was convicted on 3 separate occasions. Finally, the appellate court reversed and dismissed the case outright, and Juan got to walk away a free man. And that's because of DNA evidence. So here's what the prosecution wanted to try to do, is say, okay, the DNA doesn't match the individual who committed the offense, the one we charged. So what? There's other things. DNA is very, very strong because it's like fingerprints. It's even stronger than fingerprints because each individual has separate DNA. And so in the case of Jerry Hobbs, he sat in jail for 5 years for rape and murder. Well, the DNA evidence exonerated him, but the prosecutor still wouldn't dismiss the case right away. Finally, the public defender's office brought up the issue of the DNA to the courts, and he was released. And then the true killer was caught. We had a case like that here in Illinois, the Janine Nicarico case, where I forget the young man's name who was convicted. Anyway, I didn't know that was on. And so anyway, the individual was convicted, and then he was released because the DNA evidence tied the actual crime to a guy by the name of Brian Dugan, who was already incarcerated, and DNA evidence exonerated him. So DNA evidence is very good. And like I said again, there are many individuals. You hear over and over and over 2 ways that individuals are being released, are being held. DNA evidence is one of the most popular, but the other one you hear is forced confessions. But DNA evidence and exonerations go hand in hand. And actually, to be honest with you, DNA evidence is also a good tool for the prosecution, because it can actually let them know that they have the right individual that's charged, because the DNA scientific evidence is so good. Now, the problem that some people have argued is that if the DNA evidence is not gathered properly, then in that case, then it could give a false reading. However, we don't want to use that, because that's the same thing can happen in any instance involving fingerprints, eyewitness identification, and other methods. But DNA is a scientific method that has revolutionized the criminal justice system in terms of determining whether a person is innocent or guilty, or could have possibly even committed an offense. Okay? And so the final thing that I want to talk about is the due process clause of the 14th Amendment. And where it talks about, there's a lot of things in there, but the deprivation of persons of life, liberty, or property without due process. And what that means is fundamental fairness, an opportunity to be able to present evidence to the contrary, to be able to refute the evidence that the prosecution has as well. And so this 14th Amendment, as it points out here, applies the first 10 amendments to the states. so that the states are required to follow what the Bill of Rights says and the 14th Amendment due process clause applicable. And the second part of Section 1 of the 14th Amendment ensures that equal protection takes place. And we already talked about that in some previous sessions, in which all people should be treated, as it says, equally under the law and enjoy the same protection. So when we deal with the 14th Amendment in criminal law cases, the attorneys and the judges and everybody are bound by the due process requirements, and it seeks to try to make sure that things are right or just, as it's said, and fair. And here's some examples. If a person pleads guilty to burglary, and the criminal damage to property charge is dismissed as part of the plea, a year later the prosecutor charges the defendant with the same criminal damage that was dismissed under the laws. Well, under the due process, the state can't re-prosecute this charge. And, you know, it's not double jeopardy because the person wasn't never tried because the case was dismissed. But under the due process clause, the individual had an opportunity to respond to the charges, and the state elected to dismiss the charges, and they could not bring them back in that. So laws must be defined, and they must be definite, and laws can be void for vagueness. So the law has to be clear so that the average person understands what their rights are under the law. In other words, they're able to take the law, apply it, and say, hey, this is what is fair. And the average person would deem it to be fair, that a person is innocent until proven guilty, that they have a right to a trial, or either if they voluntarily enter a plea. If they give a statement that is voluntary, it is not coerced out of them, then due process is met again. So due process, it kind of, the words due process tied together basically say, you get a picture of it being fair. And you can't just see a person charged with a crime and lock them up. No, they have a right to a trial, and unless they waive that right to a trial by pleading guilty voluntarily, then if you do so, as in other countries, you knock out the part of due process that is so important. And so that's what I wanted to share with you. And so it's important that you understand these basic principles: the 8th Amendment, the 14th Amendment, the Due Process Clause, and how it applies. Cruel and unusual punishment is pretty laid out, and as you do your research for your papers, then you'll be able to deal with that for your written assignment for Module 6. Just listening to what I said and then going and researching and find some sources to help you out. And of course, remember the DNA evidence. Now you know where to find these two cases, the ones that they talk about, Juan Rivera and Jerry Hobbs. And if you clicked on them on your computer, it will, oops, oh, they blocked them. Okay, they blocked them here. So you won't find it in this instance because the link isn't working. Let's see if Hobbs is working. Okay, yeah, Hobbs is working. But what you can do is you can still Google Juan Rivera and Jerry Hobbs, and you can still find the information that you need. Okay, these video platforms, I don't know, they're not really working very well, so I don't know what these links were that they put in there. I've already talked to them about that for future classes. So that's about it. And so I'm going to end this session by giving you Let's go back into the classroom. The key phrase that I want you to use, and that's DNA evidence. Don't just use DNA, but DNA evidence. And with that, I'm going to say good night to you. I have enjoyed teaching this class for this brief 5.5 weeks. I wish each of you the best as you move forward in your bachelor completer program. And I may run across some of you again in other classes. And so I'm going to say have a good evening to each of you, and get those assignments in, and make sure that you have taken your time to do them right. Don't just throw anything in. So I'm going to end this session.